Every day in the USA, people find themselves in court.
Is Mr. Wilcox there?
Yes, ma'am.
Okay. All right, did you know we're going to accept your your adjournment?
I ain't said.
And for the record, in the matter of, Mr. Serrano.
He went.
Oh, shit.
What can I say?
Can you let Mr. Serrano come in here, please? And do you know where Mr. DuBois is?
Yeah, he's in the side door.
Oh, yes. Oh. Is he sitting here?
He was talking to someone. I didn't know. I should have zoomed into.
I knew it as soon as I was trying to leave the I knew this morning when I woke up. Just today, it was just kind of.
It must be contagious because I'm starting to lose my patience.
Yeah.
It's something.
Where'd you go, Mr. Serrano?
I'm taking the prosecutor on the ordinance, right?
Oh, okay.
All right. Whatever you have. Oh, yes, Mr. Wilcox.
Okay, yes. All right, we're on the record. Matter of the city of Wyandotte versus Stephen Wilcox, 25633.
Your Honor, good afternoon, Richard T. Serrano, P3328. Today, Your Honor, I appear as RBC counsel on behalf with my client currently in custody and for arraignment only, Your Honor. Please state your name, sir.
Steve Wilcox.
All right, and so today, counsel, because your client's in custody, is the arraignment, and so as the arraignment.
Your Honor, I've advised my client of the nature of the charges, all maximum penalties involved. He understands them. He's advised his rights as well, signed a rights form. Everybody will wait for him reading to stand mute today. That's
all right.
Pre-trial.
The court will obey the formal reading. Judges are not guilty for purposes of the arraignment. And then we'll schedule this matter for pre-trial. Yes. Yeah. May 21st. 8:45. At 8:45.
All right, thank you.
Counsel Esteban.
Your Honor, my client tells me that he's presently on a parole hold. He's been in touch with his parole officer, and they're aware of this. And Your Honor, he does presently have a GPS tether on, which he tells me is not working at this time. So we would hope that the court would not deem any violation of that based on his other case. I know this court did not put the tether on him, but for some reason it's not charged. But Your Honor, my client is single. He's of course no minor children. He works as a paralegal in a criminal law office in Dearborn, full time. And Your Honor, we hope the court would consider that. He does have some criminal history, Your Honor. He did significant prison time on that. And currently on parole, we would hope the court would consider a reasonable bond.
You're a paralegal, sir? With which firm?
I work for Not Guilty Law, Ed Martell and Muhammad Nasser.
What do you want to be on parole for?
Currently, I'm on parole for home evasion and criminal sexual conduct third.
And if you were to test right now, sir, what's in your system?
Pardon?
If you were to test right now, what's in your system?
Absolutely nothing. I'd be more than happy to test.
And how long have you been on parole, sir?
Since January.
You were released in January?
Correct.
25?
Correct.
It shows as though you're a parole absconder. That's why there's a warrant for your arrest for that.
I believe that's what led to this, yeah. But I also believe that I just reported on Tuesday that said the warrant was issued on Monday. I literally spoke with my parole agent in person on Tuesday, so I have to believe that there's some kind of misunderstanding. He wasn't going to let me leave the parole office if there was a warrant out for my arrest. So anytime the GPS dies because it's not charged, they automatically issue a warrant. I haven't been able to charge it because I'm in jail.
The court's going to order a $5,000 10% bond not to possess or consume any alcohol or drugs that are not prescribed. We'll see you back on May 21st. Thank you.
Like,
Okay. Okay. All right, let's go on the record in the matter of the state of Michigan versus Ian Emory, 25637. And the sergeant, your name for the record, please.
Sergeant Stephen Oborn, Oborne.
Please raise your right hand. You solemnly swear from the testimony about to give this matter be the truth, the whole truth, and nothing but the truth.
I do.
All right, thank you. You may proceed on the board.
On 5/6/25 at approximately 15:26, Officer Barwig and Officer Perez were in the semi-marked traffic patrol vehicle when they observed a gray GMC going the wrong way on 13th, which is a one-way going south. Officers able to catch up to the vehicle and initiate a traffic stop as the vehicle was pulling into the driveway of 155112. Officer Barwig made contact with the driver, as the driver later was identified as Ian Emory. Once the door was open, Officer Barwig immediately detected a strong odor of intoxicants. Officer Barwig asked Emory how much he had to drink today, and he stated he had 1 bottle of wine. Officer Barwig then asked Emory if his license, and as for his license, Emory replied, "I do not have anything on me." Officer Barwig then asked Emory if his license was revoked, and he stated yes. And if you're arresting me, this will be my 4th OWI. At this point, Emory had his dogs in his vehicle, so Officer Barwig and Officer Perez assisted Emory with getting the dogs secured in his house. After getting the dogs secured, Officer Barwig had Emory execute field sobriety test. After performing the field sobriety test, Officer Barwig determined that there was enough probable cause to place Emory under arrest for operating while intoxicated. Emory was transported to Wyandotte Police Station where he was booked. After a 15-minute observation period, Officer Barwig had Emory his chemical test rights verbatim from the DI 177 form. Emory agreed to the test. Emory submitted to the first test, which resulted in a 0.17. Emory refused to produce a second test. After checking Emory through Lean/SOS, it was verified that he did indeed have 3 prior OWIs. The first one back in February of 2003 out of Plymouth. The second one was April of 2005 out of Bloomfield Hills. And the third was November of 2020 at Tawas City. And it showed his operator's license was currently revoked.
All right, thank you. On examination of planning, what is that? Find the offense, the charge or committed, there's probable cause to believe that I committed those offenses. And counsel, your appearance for the record, please.
Good afternoon, Your Honor. Neil LeBoy here on behalf of the defendant. Sir, can you state your name?
Yeah, right. Thank you.
All right, in counsel, good afternoon, sir. And as to the arraignment,
Your Honor, my client waives formal reading of the charges and stands mute.
the court will make a formal reading after a plea of not guilty for purposes of the arraignment. Sir, you have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. In fact, you've had an opportunity to speak to an attorney today. Is that correct? Sir? Sir? Can you hear me?
Yeah, you said I was going to be mute.
No. I didn't mean to mute.
It's really hard to hear you. It was hard to hear you.
Okay. Sir, you have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And in fact, you had an opportunity to speak to an attorney today. Is that correct? With that?
Yes. Yes.
The court has also signed a request an appointment for a board of attorney for felony matters. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand all of those rights? Sir, do you understand all of those rights that I've indicated to you? It's not coming through on this end. I can't hear what you're saying.
Yes.
Okay. As I've indicated, the court's going to enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference on May 15th. At 8:45 a.m. And counsel as to bond.
As to bond, Mr. Emory has never failed to appear when any court's ever required him to. He is a homeowner here in the city of Wyandotte. He lives there with his wife. He is a tradesman. He's been a carpenter for 20 years, works at least the last 3 years for a company called Chrisman Company. And he indicates that he understands the severity and importance of this case. He will apply with any and all directions of this court to appear. We ask the court to take that into consideration, setting out on vote.
Sir. You don't have the privilege of operating a motor vehicle right now, and yet here you are charged with your fourth alcohol-related driving offense. Are you currently out on bond in any other jurisdiction?
Was that, Your Honor?
Are you currently out on bond in any other jurisdiction?
Oh, no.
If you're in a custody, what is in your system?
Nothing.
You're not on probation or whatever?
On probation? No.
All right, Sergeant, would you like to address that?
My recommendation would be 10,000, 10%. This is his fourth offense. He is driving without a license.
Sir, where is it you work?
The Chrisman Company, I'm a union carpenter.
Okay, and so do you kind of travel all over the state or?
No, actually, they put me on a 2-month layoff just because we were a little slow. So I would be going back in a couple weeks. Now,
Okay, you seem to have a couple of matters up in Oscoda County and Iosco County. Do you go up there often?
I have a boat up there. So in the summertime, I do.
All right, here's the court's going to do. The court has some serious concerns that Mr. Emory is unable to comply with the conditions of this court based on this not being his fourth offense, alcohol-related driving offense, and that he does not have a valid license and that is revoked based upon his prior convictions, and yet it's alleged that he was driving a vehicle. The court does find $10,000, 10% bond. If appropriate, the court's also going to order that you're not to be released from alcohol outside of the Wayne County Jail. You're not supposed to consume any alcohol or drugs unless prescribed.
Governor, may I address the tether requirement?
Okay?
I think that the tether is quite reasonable and understandable in the circumstances. However, he indicates he has the funds, and if it could be arranged to have EMS come here to fix the tether, to save him a guaranteed stint in Wayne County Jail for getting convicted.
Well, but the court can appreciate that counsel, but the court also you'll know that the court, in the event that there's a violation, then with your client being out of Wayne County Jail tether, there'll be immediate arrest. So the court's going to continue with the alcohol tether to the Wayne County Jail. Thank you. We'll see you back next Thursday, sir.